I've seen a lot of comments online as to what the judge has said to the jury in the Liverpool Crown Court trial of Mohammed Ahmad and Mohammed Ammaz, much of which is not helpful, which I seek to explain in this video, particularly with reference to, quote, good character. So I'll explain that generally in this video, but just first, as a caveat, if it wasn't obvious, I'm not commenting on the trial itself. I'm very well aware that this has not yet concluded, so my comments in this video are limited to what this actually means and not in relation to the trial and the case itself. So I hope that's clear. That said, these are the sorts of comments that I think are unhelpful. Unhelpful in the sense that I think it encourages other people to misunderstand what's going on and what's being said by the judge and why and what it means, etc. So comments such as this in relation to the good character reference given to the jury by the judge. This post says that the judge has told the jury that they are of good character, no past convictions, less likely that they've acted as the prosecution allege. But then the post goes on to say, quote, he's basically saying the police have lied, which is, of course, not what the judge is saying. This is taken in response to the reporting on this, where the judge did address the jury as to good character, which I'll seek to explain in this video. And also in the second half of the video, people have then compared it with Lucy Connolly, and asked about the good character there. I'll deal with that in the second half of the video. And by the way, please do subscribe if you like the legal analysis and help me to grow this channel, and I'd really appreciate that. Thank you very much. So the judge here did provide a good character direction to the jury as reported with no previous convictions. He's quoted to say, although good character is not a defence to any of the charges faced by the defendants, it is relevant in two ways. Firstly, as the defendants have given evidence, their good character is a positive feature which you should take into account in their favour when considering whether you accept what they told you. Secondly, the fact that the defendants have not offended in the past, either before or since July 23rd, 2024, may make it less likely that they acted as the prosecution allege in this case. The judge went on to say it is for you to decide how much importance you attach to the defendant's good character, and it is for you to decide the extent to which it assists on the facts of this particular case. In making those decisions, you should take into account everything that you've heard about them, including the unchallenged testimonials that were read on their behalf. Those were the judge's directions. Now, a lot of people are asking why the judge has provided a good character direction to the jury. Now, there's a short and a long version, and that's what you're here for. The short version is it is both normal and required. It is proper practice, and it would also be a point of appeal, which I'll come back to a little bit later, if that direction was not given. And the reasoning is quite straightforward, but that's the long version. Now, the bench book for judges here on good character sets out what the judge should look at. Now, interestingly, a penalty notice for disorder is not to be treated as impugning good character. So what does good character mean? So speaking very generally and not about this live case, you understand, what does good character mean? Does it mean the judge is saying that they are good people, good character, very nice and would never do such a thing, etc.? No, that's not quite what it means, and that's certainly not what the judge is saying. What the judge is saying quite simply is that they have not been convicted of something in the past. Now, there are two types of good character directions here. There's what's referred to as an absolute good character and an effective good character. So absolute good character means they have never been prosecuted for any offence, they've never been convicted of any offence, and not just prosecuted or convicted, but acted in such a way that is reprehensible so as to damage their character to the extent that it would be wrong to refer to them as having good character. Let me give you an example. Let's say that there's a live case of somebody accused, let's say, of some kind of assault or worse within marriage, domestic violence, that kind of thing. If they are charged with an offence and that is the live case that they're in court for, and let's say they were married previously and there is a history of such complaints with the previous wife, for example, but they were never prosecuted, he was never convicted, but it is an undisputed fact that they were reported, he may have been arrested and questioned about it and all of this sort of stuff. So it may be an undisputed fact that there was previous activity, which is behavior that is reprehensible and relevant, which I'll come back to in a second. So relevant and reprehensible behavior or conduct would then mean that it would be wrong to say that the defendant has an absolute good character. Then there would be a modified good character or effective good character direction to the jury. But now people might ask, well, what if they don't give evidence? What if they change their story? What if they don't mention when questioned something they later rely on in court and so on? And secondly, how does this good character relate to cases where people are convicted or plead guilty, such as Lucy Connolly? So I'll come back to all of those in just a moment. Just as an aside for a moment, I'd like to say a huge thank you to all of you for supporting me on this channel for 5 years now, but also not just for supporting me, but for supporting the partners to my channel who support my channel and assist me to keep bringing these videos to you. And one of whom is called Holy. Now, you know that I take my fitness seriously. I'm always training and trying to stay healthy. And I was going to say recently, it's actually 2 years now since I gave up alcohol. And this year I've made a real effort to increase fitness and training, and hydration is really important. So Holy is a drinks company. They produce iced teas, hydration drinks, and of course energy drinks. And they have some great new flavors out for the summer here. They have a multivitamin drink, an orange drink, and a passion fruit. These are all really tasty. In fact, I have the passion fruit one here right now. It's just a little bit of water, 1 spoon of powder, give it a shake, and you have a really delicious drink. But most importantly, it's hydration that is the real key here. If you want to get fit and you want to get healthy, hydration is the real key. Lots of you have bought these drinks from Holy. You've reached out to me and you've told me that they are great, and I see them on your shelves, which is really fantastic. You've sent me photographs of them. I really cannot recommend them enough. I drink them all the time. I know it's somewhat difficult to get the idea of a flavor through a screen, but the passion fruit is a really fruity, slightly tangy, light and really fresh drink that is really refreshing and hydrating. The multivitamin is, again, it's like a really fruity, really delicious drink for the summer. And the orange, without naming any names of other drinks providers, it tastes like some of the best orange drinks providers out there. So it's a really nice, fresh orange taste. Orange you cannot go wrong with. These are some great additions to the range. There's a whole range. I love their strawberry and kiwi, I always say. But they also do milkshakes as well. The hazelnut is probably my favorite milkshake. If you are new to Holy, I would suggest you go with their starter set deluxe, because you'll get a shaker with it as well. And of course, I'll tell you about the codes in just a minute. And right now they have a limited edition, limited range of really awesome looking shakers. I've got a bright yellow one of these. They are fantastic. They don't leak and you can carry it around with you. And of course, as a partner to my channel, you get a great discount. So you can use the code Barrister for a 10% discount off your entire and ongoing order. Or if you like a straightforward, simple discount, use Barrister 5 for a £5 discount off the order. And for summer, you really can't go wrong. You can hydrate yourself. So please do check them out. I just wanted to say thank you for supporting me and supporting my partners. So thank you to Holy for supporting this video. So now we can go back to what the judge reportedly said to this jury. And again, commenting generally, not on the case, just about what the judge said and why. Because this is a generalized thing. The judge will say similar things in every case, and it doesn't mean anything for the case in particular. And the judge effectively said two things. Firstly, that this good character, i.e. no previous convictions, etc., was relevant to whether the jury believed what they said, and relevant to whether they acted in the way the prosecution alleged. And this is very important because it's a two-limb direction, sometimes referred to as a VI direction. And it's two limbs. The first limb is a direction on whether the good character is relevant to the defendant's credibility, i.e., is it relevant to whether they are telling the truth or not? Because obviously, if they have previous convictions at all, certainly for dishonesty offences, but if they have previous convictions, etc., then they may not have a good character direction and may be less likely to be telling the truth. That's the first limb. The second limb is whether or not they are likely to have committed this offence, because quite obviously someone who has committed many or even one similar offence in the past is more likely to have committed this one. And that is where the relevance of these offences come about as well. Because first of all, the relevance of the offence will be in question Because if it's a completely unrelated offence, then first of all, the jury won't have had details of it, because there'll be legal arguments in the absence of the jury as to whether that is admitted into evidence or not, i.e., if it's a completely irrelevant offence, the live offence is, let's say, of assault, and a previous offence is of drugs possession, they're completely irrelevant, and unless the drugs previous conviction had anything to do with assault, the details of it won't be given to the jury, although it would then mean that the defendant would not receive a good character direction because they have a previous conviction, although the jury won't hear about it. So these are little clues that people watching a Crown Court trial can derive the background of the defendant and so on. Much like if the defense barrister is not saying that the defendant did not do a thing, was not at a place and so on, that usually means that the barrister knows that they were there or knows that they did do the thing. They are just arguing as to reasons why they did it or why they might not be guilty of it and so on. So coming back to this direction to the jury, it's a two-limb direction. And all defendants are entitled to it if they are of good character, meaning they have no previous convictions and so on. The first limb goes to their credibility, and the second limb goes to propensity to commit the offence as alleged by the prosecution, and it's up to the jury what weight they place upon that. So that really is it as far as a good character direction from the judge to the jury goes. The two limbs, firstly as to credibility, secondly as to propensity. And that's all it means. It means nothing else, and they are entitled to it. Finally, if the judge did not provide such a direction, that would quite likely result in a successful appeal, in that they were entitled to it because they had no previous convictions, and so the judge is obliged to provide that direction. Okay, so what happens if somebody does not give evidence in court, or they do not give answers in a police interview, or they change their story as they go along? And how does that affect the case, and what does the judge tell the jury? Well, essentially, the judge is going to sum up both the prosecution case and the defense case and direct the jury as to whether they are entitled to draw any what we call an adverse inference, meaning a negative inference against that defendant, such as to credibility, such as to propensity, and so on. Now, we've talked about previous convictions, whether relevant or not. Now, if, let's say, the defendant had a previous conviction that was not admissible because it was irrelevant or too long ago and so on, but then they start attacking the credibility of other witnesses, then it may be that the prosecution make an application to adduce bad character, i.e. the previous convictions that were not relevant, because they're attacking the credibility of other witnesses. And so that would be prejudicial, that would be unfair, and so then they might be admitted into evidence. And then, of course, that can result in an adverse inference as well. But let's say the defendant does not give evidence at all. Then again, the jury is entitled to draw an adverse inference from the defendant's refusal to testify and be cross-examined. Now, although they cannot be convicted solely on their silence, it would obviously weigh heavily in their decision as to whether they are guilty. Similarly, in response to a no-comment interview at the police station, if they then raise a defense in court that they have not mentioned in the police interview, that's where the caution comes in. You do not have to say anything, but it may harm your defense if you fail to mention when questioned something you later rely on in court. That's precisely how that works. The jury is then entitled to draw an adverse inference from their silence in interview and then bringing up some kind of defense in court that they've never mentioned before. Similarly, if they change their story, if they make one statement in a police interview, let's say it was completely different and they say, I didn't hit the guy in the police interview, but then in court they say, well, okay, I did, but it was self-defense. Then obviously they've changed their story, and then changing their story, again, is something that the jury can draw on because they've changed their story. It's a lack of consistency, therefore lack of credibility. But what if I told you that there could be good character and bad character at the same time in the same summing up and the directions to the jury? Well, that's precisely what the bench book describes in this case here. In this case, a man with no convictions had been charged with the attempted abduction of a 5-year-old child. He got out of his car, which had stopped in the middle of the road, left the door open, approached the child and asked if she had seen his cat. Engaged in further conversation, and by that time the child was in the middle of the road. Her uncle round the corner told her to get on the pavement. The incident went no further, but the appellant returned to his car, continued to drive slowly around the estate. When arrested, the appellant admitted that he'd been driving around the estate, but said that he'd been trying to free up his brakes. When the brakes were tested, no fault was detected. In evidence, he said he could not remember the child and had no recollection of speaking to her. The prosecution successfully applied to adduce evidence of the appellant's behaviour on previous occasions. 2 years before, the report was made to the police, supported by reputable witnesses, that the appellant had been loitering at a children's playground, approaching and watching children. He'd been employed by the firm which installed the playground, and the appellant was claiming that he was just taking a professional interest in the work that he'd done. The Court of Appeal upheld the judge's decision to admit the evidence. Even if it was not evidence of propensity to abduct a child, it was evidence capable of being similar fact evidence within the pre-act, meaning given in the evidence. In the summing up, the judge said as follows. So this is both good and bad character at the same time. The judge said, knowing that it might help you to resolve an issue which has arisen, namely whether the defendant has the propensity to commit the kind of offence with which he is now charged, namely abducting a child, the prosecution say the evidence demonstrates that he has an unhealthy interest in children and therefore makes it more likely that what he was doing was attempting to abduct a child. But of course, keep it at the forefront of your mind at all times that he was never convicted of any offence arising out of the earlier incidents. In fact, he was never prosecuted for any offence. Providing you exercise caution and bear in mind those points, i.e. his innocent explanation, you may use the evidence of what the defendant did if you think it's helpful to do so when considering the issue of whether he has propensity to commit the offence with which he is now charged. And then the judge went on to make further comment which essentially amalgamated a good and bad character direction at the same time. So effectively saying if the jury believed the good character bit, they're entitled to take that into account, but at the same time, if they felt that it was useful to think about it as bad character, then they could also consider that. So finally, how does this apply when someone has been found guilty or pleaded guilty? Because I've seen in some comments where people have said that this was not applied to Lucy Connolly. Now, completely different offence, first of all, completely different case, completely different situation in that she pleaded guilty, she signed a lengthy statement and so on. But good character, as in no previous convictions, is certainly considered when passing sentence. And the judge did so. It is even in the sentencing remarks here at paragraph 17. The judge says, as to mitigation, you're now 41 years of age. It is clearly a mitigating factor that you have no previous convictions. I've also read the character references on your behalf from those that know you. They speak of a caring person, including those for whom you acted as a childminder for their children. You have good family, young daughter, etc. So the no previous convictions, good character was certainly considered in this case. But people then ask, why such a lengthy sentence? Well, this is where I have a bit of an issue with the sentencing guidelines, because it's not necessarily the judge that you should blame for this, because as the judge correctly pointed out here, the starting point after a trial is one of 3 years imprisonment. And so the judge is going by the guidelines. So I hope that's some use in helping you to understand how good character directions apply, how they are standard, how it doesn't mean the judge is siding with the defendant and so on, and how they apply in sentencing. So I hope you found that interesting. Please do like the video and subscribe. I'll really appreciate that. And as always, thank you for watching.